going to go ahead and get started. My name is Seth Bloom. I'm Senior Director of Attorney Services here at LevelSet. Today's webinar, we have two lawyers with us, and we're really excited about that. It is Construction Attorney Guidance, Avoiding Payment Problem. And so I wanted to introduce today's panelists. Ben House, he's a partner at House, Perron & House, and they are in the greater Houston area. Andrew Wyman, he's a founding and managing partner of Wyman Legal Solutions in Boca Raton and does work all over the South Florida area. And some of the topics today that we're going to cover is why getting paid is such an issue in the construction industry, proactive steps contractors can take to avoid payment problems, success stories of construction companies that have kept non-payment issues at bay. So those are some of the things we're going to tackle today, and we're going to talk about them. So I can start with Ben, but why is getting paid such an issue?
Oh, well, every possible way a contract can go wrong or a fight can happen, your leverage is payment. If somebody's fussing at you for not doing something you were supposed to do, their leverage is payment. If a sub has failed your leverage is payment. If you're a homeowner, your leverage is payment. And then all the way up the chain of contract, if payment is interrupted somewhere up there from either owner, general contractor, or anywhere on down, and if it's up high, that's the dangerous one, then a lot of contractors default to, well, regardless of what their contract says, if I'm not going to get paid, my guy's not going to get paid. But I've been lucky, had many clients that say I'm going to keep paying my guys no matter what, and we're going to get this dispute figured. But I would say that's probably the exception more than the rule. So really, all roads lead to not getting paid. So that's why you need to exert some pressure backwards.
Well, that's what our company is about, getting our customers, getting our contractors paid. So Andy, do you have anything to add to that?
Yeah, Ben's right. Ben's right. I mean, especially when you're running a business, if you're a small business, cash flow is just so important. And if, it's being able to predictably receive money on the jobs at the point where you're expecting to get them, that's going to keep your business alive. It's going to allow you to have a little bit of wiggle room on those jobs that may not be, moving along as you want. So, and again, as Ben pointed out, that's the pressure point, payment. Owners, they want to hold as much money to the end of the project or as close to the end of the project as they can. Contractors want to get that money front loaded where they can. There's a sort of a natural, a disagreement there that you really got to make sure you work out at the beginning of a project, how those progress payments are going to be made, when they're going to be done, and, make it predictable so everyone understands at the beginning exactly how it's going to work.
Maybe one of you can expand on that and actually give like a real world story about why payment is so important. Not only to the small, we understand that if you're the smallest company, and you're waiting on a payment for a big job, that, this could really, you might have to lay off workers, you may have to bankrupt the company, but explain maybe even at the small to mid-sized level, how important these payments are and how disruptive it could be if they don't get paid timely. If one of you have a story about a past client that maybe would illuminate that.
I'm going to punt that to Andy because that's really his wheelhouse.
Okay. It's, the big problem that I see when it comes to payments and timing of payments really is contractors not being real clear about what their expectations are from the beginning, or binding the other party the proper way in the beginning. When you're on bigger projects and you're a subcontractor, sometimes it's a matter of bargaining position, and sometimes it's you want this job so bad that this contractor is offering to you that you're willing to accept uncertain payment terms or language in contracts that you frankly don't understand or haven't seen before or haven't worked under, to where you might be at the whim of some owner, and if the owner's not paying the contractor, they're not going to pay you, even though you've done your work and you've got workers who are ready to get, and deserve to get their money. So a lot of the work that we do with contractors is upfront. I have a lot of subcontractor clients who will present to me the contract that they get from these contractors, and they say, hey, here's what you're going to sign. And our job is to go through that and prepare basically a rider that the sub can send back to the contractor saying, hey, okay, we'll accept the contract, but with these changes. And then look, again, sometimes it comes down to negotiation and bargaining power. And if the contractor knows that you're going to be a stickler for standing up for yourself and standing up for your rights, he may go elsewhere with that job. Has to be something you're willing to accept, though, because that's usually better than working on a job under some really bad contract terms.
Well, thank you for that. I'm sure there's a lot of people out there that completely understand that situation and are going to take some of that advice.
Sure.
The next one we'll talk about is steps to take to avoid payment problems. And I know that's a pretty big area. And Ben, since Andy just finished talking,
Sure.
I'll start with you on this one.
Yeah, well, it's funny. We're putting on a presentation with Level Set here, and there's a reason for that. Liens are good, so figure out how to do them. Whatever state you're in, I'm in Texas. Our lien law is just wild, and by wild I mean not very good. It's very difficult to follow. Lawyers struggle with it all the time. It causes disputes. It causes litigation. My clients who are your mom and pop subcontractors, even your really, frankly, rather sophisticated mid-tier $5 million plus operation subcontractors don't have a chance. You can hire personnel for this and you don't have a shot at getting it right. You can hire a CM out of college, which is what I went to school for, and we're not going to have a shot at documenting the project properly to get you a lien, at least in Texas. It's that dense, it's that complicated. There's a lot of reasons for that, which I won't go into right now. And the second step I would say is you have to understand your contract. It's what Andy said. You got to talk to somebody about it on the front end. I have subcontractors who routinely, just here in Houston, got an 80-page subcontract back, sends it to me, and I did exactly what Andy said. I lined out the issues, but at the end of the day, I told them, and we're here talking about payment. My advice was be capable of funding this project yourself. Have whatever you need in place to fund this project yourself. Pretend you're not going to get paid till the end of the day and maybe later. Be prepared for that. Not everybody can do that. These folks I knew could, but sometimes that's what it takes.
Andy, do you want to elaborate on that? Or
a little bit? I think, again, certain subcontractors are saying it's not everybody, but they're almost afraid sometimes to be assertive about their rights and the rights to get paid. And if you're a subcontractor, I'm in Florida. If you're a subcontractor and you don't have a direct contract with the owner of the property, there are steps you need to take at the beginning of the project, sending a notice to the owner and the contractor, that is going to protect your right to maybe file a lien later on, should you need to do that. But if you don't take that initial step, you blew it. You never have the right to file a lien. Some contractors are, at the beginning of a project, things are going well, problems haven't really developed. They kind of think that if they do something like just send a notice to owner, which protects them, that's going to be looked somehow as being an aggressive step that is going to be looked down upon by the contractor or the owner, and they're all of a sudden going to be put in a bad light. I would strongly encourage you to get over it and realize that all you're doing is you're standing up for yourself. Again, a notice to owner it's not a lien on the project. It doesn't create a problem for anybody. It's statutorily in Florida, the step that's necessary for you to take to make sure you can protect your right to get paid later on. And you're the only one who suffers by not sending it. And frankly, I think that there is a respect to be earned by these larger contractors, especially if you're jumping around in the pool with them for the very first time, that you follow what the statutes require and protect your rights. They'll realize that you know what you're doing as a contractor and a business person. And I would think that, as they'll respect it. And I think they'll treat you better if they know that getting paid is important to you.
Thanks. That's super helpful. I think I have one question, which I know, Ben, you alluded to. We started talking about mechanics liens, and that's something that here at Level Set, we've been doing in all 50 states for a number of years, helping people file mechanics liens and making sure they get paid. But maybe you alluded to, Ben, that Texas has so many complicated laws regarding liens. So I thought maybe you could point out some of those unique legal challenges, and then maybe Andy, you could chime in on what Florida does better or doesn't do, because I know people out there watching from Florida and Texas.
How could you do it worse?
No, they're kind of similar states, kind of dissimilar.
They are procedurally in a lot of areas. They are. Yes. Okay. So homesteads in the Constitution, Texas says you get a lien as a mechanic and materialman on homestead, except then they statutorily came through and said somehow the statute gets to augment requirements of the Constitution, which is, I always thought that was iffy, but the courts have kind of blessed it. And therefore, there's additional requirements, such as where the contract with the homeowner is actually signed, the office of either an attorney or a title office, or I think there's one other option. And if it's not signed there, you're SOL for liens on a homestead. So when I have folks call me up and say, hey, I want to lien on this homestead, if it's not new construction, which is a loophole to that issue, man, you're in trouble. And you know, when you're litigating against a homeowner, what everybody's largest asset is what? Their home, right? And if the home is not an asset, and in Texas, if you don't have a homestead lien, you can't go after a home. It's not possible. We're kind of a debtor haven historically, and a lot of those laws still exist. Same with Georgia, and I think probably a little bit in Florida. So if you can't go there, you can't go after their cars, you can't go after their personal effects. It's just a homeowner, and they're what we call judgment proof a lot of the time, even if they're fairly well to do in Texas, and frankly. So I have given that speech a lot, and it's a bummer. So you got to line it out in the beginning, for sure. Got to know.
Andy, any nuances in Florida about filing liens? Is it easier? Is it harder than what Ben's sounding in Texas, or anything that people should be aware of?
I think it's it's not complicated to get a lien filed. I mean, but the laws themselves are very unforgiving, right? There's a lot of timelines you need to be aware of, both on the front end of a project, notices you need to give, your timing of these notices, your timing of liening the job itself. And it's different if you're a contractor with a direct contract with the owner versus a subcontractor versus a material supplier, right? I mean, you know, if you're a material supplier, for example, you know, again, likewise, you have 45 days from your first providing of labor or materials to the job in order to send that notice to owner. That's going to preserve your lien rights later on. But it's even if you're a material supplier that is specially fabricating particular materials for that job, your time frame may start even earlier for when you start fabricating those materials and not when they're delivered to the job. I mean, there's just a lot of little nuances like that can really trip you up, that I know the folks at Level Set know all about. And it's, you know, when contractors come to me about getting a lien filed for them, sometimes I do that. Sometimes I direct them to Level Set, because and on notice to the owner, I always direct them to Level Set, because it's just you guys just get it done much more quickly, and it's always right. So I encourage the contractors to be working with someone, either a lawyer or a company like Level Set, and not try to just take it on their own. Especially when if you on a lien, you can include, you're only entitled to lien for work you've actually performed, for the value of work you've actually performed but not yet been paid for. A lot of contractors don't understand that. They put in whatever's left due and owing under the contract that they haven't been paid, or they're adding their attorney's fee into it, or certain other charges that they're not allowed, and that'll invalidate a lien on its face right off the bat. And so, I mean, it's just tricky, and you need to get the guidance.
Thank you for the plug, Andy. We appreciate it. And we're always looking to file liens when people need them to help them get paid in Florida. I guess we touched on this a little bit, but I'll start with you, Andy, because I know I've let Ben steal your thunder a few times by kicking it off. But just some stories of success you have, either working with Level Set, if Legal Guard's appropriate, and/or we'll talk about Legal Guard in a minute, or just some things that you found that help people get paid and have been successful procedures to kind of smooth out business operations.
Yeah, so lots of times when I'm first meeting a contractor as a client for the first time, it's usually because something has gone wrong on a job. They haven't been paid for one reason or another, and maybe it's and I ask to see their contract that they use, and it then becomes pretty clear why, right? I mean, and usually it's a contractor they used to work for somebody else, and now they've opened up their own shop and they're out on their own, and they've Frankenstein together some contract that their former boss used to use, and half from, what they Googled and found online. And it's internally inconsistent, and it creates, confusion, and confusion coupled with usually a lack of communication between a contractor and an owner is usually what will lead to payment problems. So the goal is, you come to me, and we may or may not be able to get you paid on that job based on what you might have already messed up or screwed up along the way. But the goal is to make sure that we learn from that experience and that it never happens to you again. And so to work with a lawyer to fix this contract so that you have a reliable, predictable, document you can use and present to customers going forward, is how you cure that for folks. And having a lawyer you could trust and go to do that for you and with you is where the success comes from down the line.
I think that's something we try to stress here, and I think one of the goals of Level Set is for that proactive legal work, is getting things done right from the start correctly. And as we'll talk about Legal Guard in a few minutes, I think that's one of it's much better, it's much less expensive. You get paid easier if you're proactive versus reactive. But of course, as you illuminated in your first few seconds there talking, Andy, most of the time when people come to you, it's because they have a problem, and sometimes that's too late. But hopefully it's a small problem, and they can now correct that and get into a better flow of good legal hygiene, as I sometimes like to say.
That's a good phrase. I'm still in that.
Construction.
Good legal hygiene. That's good.
And Ben, where are you on this?
It's good legal hygiene is I'm still in that. That's literally the perfect way to put it. If we're on the broad spectrum world of self-help, as a contractor in 2021, or even really in the last, frankly, 20, 15 years, you cannot afford to not be somewhat sophisticated in the lien and contract world. Handshake stuff it's just not there anymore for the huge percentage of projects that I deal with. And frankly, when somebody knocks on my door and says, hey, we worked with Level Set whoever, to a family attorney, whatever, to try to get these liens on file, I go, yes, okay, we got something to work with, let's go. And if they don't, and it's 6 months down the road, because usually, like Andy alluded to, nobody's complaining because they're upstanding people and they just that doesn't feel right to them. I've got a breach of contract case, or there was somebody in the chat that said, hey, can I lien up a governmental entity, a state? And I answered, yeah, you can, in Texas at least, and you better, because if you don't have any other rights. You can't sue the state on a contract unless you've got your lien rights here. So it's just absolutely critical. I don't even have my backup plan of a breach of contract suit.
Sure. We'll move on to the next spot, and that is Legal Guard. I think this is a good segue to Legal Guard, and it's one of the new products we have here at Level Set. And I think why it's so important is because we just started talking about proactive versus reactive legal support and how that can help you get paid quicker. So real quickly, and thank Andy and Ben, and we're going to hear from them again in a few minutes about all the information they've been giving you about getting paid. Two things about them is they're both in our Legal Guard network. So what Level Set Legal Guard is Legal Guard is a legal plan for people exclusively in the construction industry. And that means you could be a supplier, a sub, a general contractor, roofer, plumber, and any of those things, and utilize Legal Guard. What Legal Guard does is it's a subscription-based model that's paid to Level Set, and then we pair you with a lawyer in your area that's a construction lawyer that handles construction disputes, that's already been vetted by us, so we know that a substantial part of their practice is handling construction disputes. From there, you'll be able to get certain benefits from that lawyer. You'll get free consultations, you'll get some analysis of your legal problem. In addition to that, you'll get 10% off whatever the fee is, whether it's a flat fee or typically an hourly fee. But I think one of the big parts of this to understand is that this is letting someone like Ben or Andy make sure you're doing the right things with your business from a legal standpoint so that you don't get into these payment problems. And I think that's really where Legal Guard shines as a proactive legal solution. Having a lawyer ready if there's a problem, having a lawyer look over contracts, write a letter if need be, or just give you the analysis and the insight that you need before making a mistake. A lot of times, just like Andy talked about, the first time a potential client is calling you, and a lot of times when people are purchasing Legal Guard, they have significant legal problems. Although we want to give you discounted legal help and more access to construction law, if you have been, as Ben liked it, if you have poor legal hygiene and you're calling Ben up after buying our subscription and you have 5 pending lawsuits against you, the subscription's not going to cover that. And you're going to be way outside of the scope of the subscription, and you're going to have to put down a traditional retainer, and you will get all the benefits of Legal Guard, but you will be billed for that type of work. So I just kind of wanted to go over what Level Set is, what Level Set Legal Guard is, and how it can be used, and how we're super excited about selling it and offering it. We're in 17 states now, plus DC, including both Florida and Texas. So we look forward to connecting more people with lawyers like Ben and Andy through Legal Guard. So, and if you ever have any questions, you can email my team or me directly to talk more about it. Right now, I'll open it up to everyone in our group about questions. If there's any questions out there you may have, give me a moment and I'm going to pull them up, and we'll have Ben and Andy, or if there's a question for me, I'm happy to answer it.
I got to brag a little bit, Seth. You say Level Set sent me a company to assist. Oh gosh, probably a couple months ago now, and worked through it, and without litigation, paid 100%. I'm kind of proud of that one. That one just came in the other way, and I was thinking, man, that's, even with lien filings, Andy can probably tell you how often they just go, yeah, okay, cut you the check. It's not always. Yeah. So it's not even close to always. So it just gets you kind of in line, which is good. But that was a good feel good moment, and the client was very happy, of course. So it was neat. It's a good bridge. Level Set's a cool bridge so far.
All right. So, okay, I have a couple questions here. This is from Lewis. Are you going to cover government / public works contracts, bond claims, and such? Well, we didn't. But if one of the two of you want to jump in and give a quick highlight of that, then that would be great.
Most of my work that I do is on the residential side, more than commercial, and so I don't really have the occasion to be dealing with the government on the opposite end of contracts or too often. I am familiar though with how with bonds, with performance bonds and payment bonds, and certainly like in Florida, like the the notices that are required, a notice to owner. There are notices likewise that are required under bonds in order to preserve your right to make a claim against a bond. And a bond is like any other contract. I mean, it's what you need to do is in there. It may not be easy to understand or read, and you may need a lawyer to help you. But there are there's a lot of similarities between dealing with payment bonds and liens in the state of Florida.
Okay. Ben, there was a question from Carissa. I understand you already about the ability and inability to file liens against a state agency, but you answered that. Someone asked a California question, so why don't you post that in our expert center on our attorney Q&A and get a California lawyer to answer that. I don't want to put either these two lawyers or myself. I know I'm not, but I don't think either of you are barred in California. So we'll stay away from that.
Nope, can't help. Sorry.
That doesn't mean we can't help. We do a lot of business in California. We have Legal Guard lawyers in California. We have Level Set Attorney Network lawyers, in California. So we do have a lot of energy in California. So we post that on our Ask a Lawyer question, and we'll definitely get you some answers. Let me see if there's anything else here. A lot of California. So, okay. Do notices have to be sent to all parties listed on the deed, or only one that this person particularly had a contract with?
I can't tell you. I can't get that specific without knowing the state. If it's California, I don't have a clue. If it's Texas, no. But it's safer to do it that way. If you have multiple parties owning a section of real estate, you could ostensibly go to who's acting as the owner on the project, because Texas law is a little wider there. It actually lets you be wrong. The word is purported owner. So if somebody's acting like the owner and it has represented to you that they own the property, you can just send it to them and you're probably safe. But I, as a lawyer, I pull that deed and I see a bunch of owners. Oh, they're all getting everything. Yeah, 100%. And if you're handling on your own or through Level Set and you're entering the owner information in Level Set, I can't think of a way that it could hurt you to utilize, because you can always, if you end up liening the wrong owner or an ex-owner or somebody's not on it anymore, just file a release of lien on that owner and you're good.
Yeah, I agree. Yeah,
Probably.
It doesn't hurt you by noticing any and all owners that you believe have an ownership in the property itself. If you're a subcontractor, you may not, you have your contract with the contractor, but you don't necessarily know who signed the contract with the contractor. You don't always have access to that document. Should, but lots of times you don't. In which case, you're more or less looking up in the public records the owner information for the property that you're working on in order to be able to send this notice to owner. And yeah, you're going to just list everybody.
Yeah, in Texas, there's a requirement that the owner or general contractor, I think both are required to send subs that kind of information if it's requested. The problem is that in the statute, they forgot to add any teeth to it. So if they just ignore you, you're kind of, okay, what do I do now? So you got to get a little angrier.
Yeah.
I'm going to let another question or two come in because we've got a lot of energy here, a lot of questions. Only a few of them are about California, and I know that person.
Sorry, Californians.
We do have lots of lawyers in California. We have Legal Guard in California. I know we've been answering that on the side chat here, but just wanted to make sure that's hit us up. We'll get you some Legal Guard real quick. Elizabeth asked, we work as a specialty subcontractor. The contracts occasionally state that the GC pays us after they get paid. Any way around that? Ben, I know that's.
So in Texas, there's two versions of that clause. It's a paid if paid or a paid when paid. They're both legal in Texas. One of them has a reasonable limit where if they don't get paid for and do not pay you for an unreasonable period of time, the law kind of takes over and says, yeah, nah, you got to. But paid if paid is legal, which means if they are just not paid above you, yeah, you're not paid either. And in that circumstance, you better have a contract with your sub that says that puts those requirements above you from your GC into your subcontractor below you, so that if they have a paid if paid clause, you better have a paid if paid clause, because then you're protected to the same extent. But if you don't, you can absolutely legally be left holding the bag. And I've had many clients just be shocked that that's the case.
Yeah, those two clauses can be so painful for a subcontractor when you're down the line, and if it's a paid if paid clause, and you're at the whim of an owner, someone you don't have a contract with, and so that becomes really tough. But yeah, Florida also has these prompt payment laws that will sort of kick in if too much time has gone by and the contractor has received the payment but has not paid you.
Yeah, and Texas does have a version of that law too. If I'm not mistaken, I haven't looked at this in a little while, but I think Texas gives you the right to contract around it. So if you're in if there's one of those 80-page contracts I was talking about earlier, you betcha there's a section that says the Texas Prompt Pay Act is out the window.
Yeah.
Gotcha. Well, we're a few minutes over our 30 minutes, and I want to respect everyone's time.
I want to answer one question I just saw come through that deals with Florida, though. Somebody asked,
absolutely,
if a contractor has to be licensed to be able to place a mechanics lien, and I think it's important.
Great question.
That in Florida is real strict about the fact that if the work you're doing requires a license, you better have a license, and that flows through to the mechanic lien rights and construction lien rights too. So if it requires a license to do the work that you want to lien, then you have to have the license. If it's work that doesn't require a license and you've worked and improved the property, but it wasn't work that required a license, then you can lien even if you have no license.
Is that the same in Texas, Ben?
It is to probably a lesser extent because we don't license general contractors here. There is no license for general contractor. It's Wild West. So there's been movement in the legislature over the years to try to do it, but I guess we're just a little too libertarian to let it happen. But mechanic, electrical, plumbing, yes.
I got a toolbox in my truck. I'm only 3 hours to the Texas.
Stick a sign on your car door, man. You're a general contractor.
Well, look, I really appreciate everyone that attended the webinar today. Special thanks to Ben and Andy for taking time out of their busy law practices to do this for us. To answer everyone's questions, we're going to do more of these. I know we had a lot of California energy today. We certainly can have. We do have webinars about California law that to you. We also do have the Q&A section, which I know some of these questions will be posted to, and you can post them or we'll post them, and we'll get lawyers in your area in California to answer them. I saw some Kansas, Missouri people too. And I will caution you that you should, you know, most law is different in every state. The language can be different, so you shouldn't rely on any of this unless you're in Florida or Texas and you heard Ben or Andy specifically speak about a certain issue, because other than that, it may not be applicable. I'm in Louisiana, and certainly here in Louisiana, some of our laws are very different. But I wanted to thank everyone again. Levelset.com. Come check us out. Legal Guard, 17 states plus DC in California. We're ready to sign you up and get new subscribers and help you get paid and help you get that legal help that I know everyone needs. So thanks again to everyone, and have a great day, and look forward to seeing you soon. Bye-bye.